When someone in an active bankruptcy passes away, both bankruptcy and probate law are involved in determining the outcome. Whenever anyone passes away, whether or not they're in bankruptcy, that person's debts aren't passed to their heirs. However, the deceased person's assets are used to pay their debts first, and then any leftover assets are distributed to their heirs. So the deceased person's debts will get paid from the property of the deceased. But if the decedent is in bankruptcy at the time of death, those same debts are already in the process of being wiped out, and the type of bankruptcy determines whether the debts are paid. If the decedent is in a Chapter 7 bankruptcy, the case will finish up and the debts will be wiped out the same. The only money that gets paid on those debts comes from money or property that a Chapter 7 trustee could have recovered in the bankruptcy had the debtor survived the case. In other words, if all of the decedent's assets were protected by exemptions, and there were no other funds that the trustee could recover from sources such as preference lawsuits, then the dischargeable, unsecured debts are simply wiped out and all of the decedent's assets go to the heirs. If the decedent is in a Chapter 13 bankruptcy, things get a little more complicated. In a Chapter 13 bankruptcy, the debtor pays back certain debts over time through a repayment plan, which lasts for 3 to 5 years. If there are remaining payments to be made, then the decedent's family has the right to finish up the payment plan. The family could also request a hardship discharge or convert the case to Chapter 7. For more information on how bankruptcy and probate law work together, visit us at www.kansascitybankruptcy.com or kansascityestateplanner.com, or call for a free consultation with one of our experienced bankruptcy or probate attorneys. At WM Law, we are here to help.